So this is your first video of two on the U.S. Constitution. I think the first question we should ask ourselves is how should we look at the Constitution? One way to look at it is as if it were a divinely inspired holy treatise full of all sorts of eternal truths that we are supposed to just revere and bow down to. And I can't do that personally. The Constitution was written by human beings, and it is what it is. It's a document written by people who made a lot of compromises and probably made a lot of mistakes. So, and divine inspiration had nothing to do with it. Another way would be to look at the words and sort of cherish the words of every phrase as if they had enormous significance that we should live by today. That leads us to all kinds of issues like what do the words mean exactly? What does due process of law mean, for example? I mean, there's so many words that and phrases that require interpretation. And people will say, let's resolve that by determining the, quote, intent of the founders and live the way they wanted us to live. And I don't know how we do that. One problem with that is, first, who wants to live according to the preferences of someone who lived in 1787? What did they know about the internet? What did they know about TikTok and cell phones and so forth? Nothing. And the other thing is, like, what was their intent? I mean, there were a whole bunch of these people involved in the Constitution, and they disagreed about all sorts of things. So whose intent are we supposed to follow? There were many different intents. And another way to look at it is to say the Constitution is a living document that each generation of Americans has to think about and try to adapt to the needs of their time. The thing is, if we do any one of these things, all these things have problems. If it's a political document that is living, then what is its fixed meaning? Does it have any fixed meaning? Or does it all change, or only some of it change? So there are pros and cons to each approach, and you can look at it any way you want. One famous constitutional law scholar named Sanford Levinson came up with a way to look at it that I think is very interesting. It was in a book that he wrote called Constitutional Faith. And there's two ways to look at this. It's a 4x4 table, even though you see there are six squares, but the two, it's really a 2x2 table. The rest of it is labels. First question, what is the Constitution? What should we look at? What do we consider when we say the Constitution? And the second, and that's down the side. One option would be the words of the Constitution alone. Another would be, well, the Constitution is the words of the Constitution, but we also have to consider other authoritative documents written at the same time, the Federalist Papers, the notes or minutes of the Constitutional Convention taken by James Madison, et cetera, et cetera. And what about the events of their time? And what about continuing interpretation of the document as subsequent things are discovered about the way it was written? What are the things that historians have discovered? So he says, that can be analogized to the way Protestants and Catholics view the Bible. Now, this is not to be taken literally. He's saying this is just a metaphor. But if you say you take the words of the Constitution alone, that's a bit like many Protestants view the Bible. We go by what's in the Bible. Whereas he points out that, many Catholics view papal encyclicals and other authoritative documents that come from the Catholic Church as also being essential to understand, what the Bible means. Now, so if you see, he calls those sort of Protestant, in quotation marks, Protestant and Catholic ways to look at the Constitution. The words alone or the words in context of other documents and things. Then going across the top, who decides what it means? Now, the more, quote, Protestant, so to speak, way of doing that is to say, well, anyone can read it. You hear a lot of people say this. I read the Constitution. I know what the Second Amendment means, but another way to look at it that other people have is only judges and constitutional scholars and historians can really understand what it means. And so if you do this, you can come up with four different ways to do it. One, I can read the Constitution to decide what it means, and I don't need to read anything else. That's the top left there. Another, I can read it and decide what it means, but it includes a whole lot more than just the 1787 text and amendments. Or you could say, only experts can understand it, but only the text matters. Or you could say only experts can understand it, and there's a lot more to it than in the text. And part of this revolves around this originalism debate. We're going to talk a lot about originalism down the road here, but The people who call themselves originalists claim that they want to see the Constitution interpreted in light of the way it was understood by the people who wrote it and what the words mean or meant at that time in today's context. It's a very, in my opinion, a very difficult way to interpret the Constitution. But we'll have a lot to say about that. Let's talk a bit about the actual political context in which the Constitution was written. What we had at that time was a very stratified society with people who had a lot and people who had a little, elites and masses, people who had wealth and power and those who did not. That was dealing with a lot of economic problems. This is 1787, it's after the Revolution, a lot of political restructuring, a lot of turbulence following a very long and destructive war of independence. You had 13 separate nation states because each of the states viewed themselves essentially as being an independent nation state. They had their own money. They wanted to make their own foreign policies. They were having trade wars with each other. And what they had at the time was a really inadequate governing document called the Articles of Confederation that did not even create a national government that was strong enough to meet the challenges that it faced, both internally and externally, foreign policy, disputes among the states. It couldn't solve any of its problems. The national government was just too weak. So we had, people trying to govern the country through 13 separate state legislatures, and it just wasn't working. Why the elites in that time, including not just rich people, but everyone really who had a significant amount of education and expertise in how government worked, the vast majority of them felt that the state legislatures had too much power and they needed to get a strong national government, that they needed to amend the Articles of Confederation at the very least. So there was a lot of dissatisfaction in 1787. That's why they held a constitutional convention. Now, just in stark political terms, the Constitution can be said to have addressed some of these issues in some very particular ways. The class structure of the pre-revolution colonial society basically influenced the way the Articles of Confederation operated. So the Articles basically empowered the less affluent sectors of society because they were the ones who had most of the power in the state legislatures. So, and these less affluent people were supported, shopkeepers, farmers, etc. They were supported by some political radicals who were, for their time, kind of viewed as radical Democrats. They might not be viewed that way today, but at the time they were viewed as believing in, sort of a radical approach to more democracy, which by today's standards we wouldn't think was so radical, but they did. Now, the economic and political elites were very unhappy with this situation, and they essentially scrapped the Articles of Confederation entirely and drafted an entirely new constitution that, to a substantial extent, put them back in power. Now, that's all true, but what we're here to talk about mainly is not just the politics of it, although that is very important, but the big ideas of the Constitution that really matter to us today. There are a lot of differences of opinion about what those ideas are. Not everyone would agree with me that these are the big ideas, although most people I think would. And I'm not saying that we're living up to them. All I'm saying is these are foundational ideas that are right there in the main governing document, apart from all the politics of it. These are ideas, and those ideas stand on their own 2 feet, and they can be cited in cases and in political rhetoric and elsewhere as principles that we are supposed to be living by. Whether we do or not is another question. And the ones we're going to focus on are limited government and constitutionalism, which I'm going to go through each one of them briefly, republicanism, popular sovereignty, federalism, separation of powers and what we call checks and balances, individual liberties, and equal protection of the laws. Now, limited government and constitutionalism, this, you could find this principle in Locke's Second Treatise of Government, a very influential text that the people who wrote the Constitution were very familiar with. He said everyone has natural rights, including the right to own private property, which is very important to him. But he said, without a government, you can't really safeguard your rights. And that is a very, what he called, inconvenient situation. So people set up governments to protect their rights, particularly the right to property. But the governments, he said, should only have limited powers. Unlimited government is tyranny, in his view. And he felt that we had the right to overturn government that exceeds its powers or tramples on natural rights, especially the rights of property. And this is what we sometimes call a social contract, an agreement in essence between people and a government. The government agrees to limitations on its power. The people agree to obey the laws, without being forced to. Now, in our society, that's in the form of a written constitution. The social contract, so to speak, is right there in the Constitution that we're talking about. There are a few societies like the United Kingdom that don't have a written constitution. They claim to have a constitution but didn't write it down yet, but I'll leave that to them. I don't know how that works. Republicanism. Okay, the idea here is if you look at Federalist number 10, which we are going to do, you will see that the people who wrote the Constitution did not believe in direct democracy. They thought it, oops, I left a liner here. They felt that that was turbulent, violent, unstable. They believed in what they called the Republican principle, which says that qualified citizens should be able to vote in elections to choose representatives who would make the decisions for them. The people don't make the decisions. The representatives do. The people choose the representatives. That's what they mean by the Republican principle. Now, in a system like that, of course, elections are very important. They have to be free, fair, open, and there have to be protections for political discourse, or the elections are meaningless. One thing they never thought about in those days is unlimited influence of billionaires over our elections, which has been enshrined by our Supreme Court in the Citizens United decision, which we are also going to talk about down the road. But this is among many things that the founders never thought about. 3, popular sovereignty, and this is where I'll refer you to the preamble. We're going to have a whole session on the preamble down the road, which says, "We, the people of the United States, do ordain and establish this Constitution." So what do they mean by the people? They did have some notion of the people being the ultimate sovereignty. That's what that means. The ultimate sovereign is, quote, the people. But who did they mean? Who did they include and who did they exclude? Very important. For federalism, foundational doctrine, really, our system of government in the Constitution allocates responsibilities between 2 different levels of government, national and state. So originally there were 13, now there are 50 state governments. Now this is a very complicated, constantly evolving doctrine about how that extremely sensitive relationship between the states and the federal government is supposed to work. You could argue, and I think it's really true, that our system of federalism completely failed at least once, and that was when the Civil War happened, because a group of states basically said they were seceding from the country because they refused to obey a national rule that had not even been passed. They anticipated that eventually slavery would be somehow abolished or curtailed, and so they left, the Union, and there was a horrible civil war in which 600,000 people died to settle this issue. That our federal system could not resolve this issue over slavery. It was solved by war, in which ultimately slavery was abolished by the 13th Amendment, and there is no right to secession. Contrary to what people from Texas and elsewhere might think, there is no such thing as a right to secession. No state has a right to secede from the Union. Separation of powers and the related concept of checks and balances. You're familiar with this probably. 3 branches of government. The legislative branch makes the laws. The executive branch implements and enforces the laws. And the judicial branch resolves disputes that arise under the laws. That's their basic function. But it also includes, the judicial power also includes the power of judicial review. I'm going to talk about that. Marbury versus Madison, 1803. The Supreme Court allocated to itself, with no text to guide it from the Constitution, really, they claimed they were finding it there, but it's not there in so many words, the power to decide whether a law passed by Congress or an executive action violates the terms of the Constitution. So separation of powers and checks and balances is about how the different branches of the government deal with each other and how they limit each other's power so no one branch can become dictatorial. 6, individual liberties. Now, this is a really interesting aspect of the Constitution. It's important to understand this. As Barack Obama pointed out, and this is true, The most of the actual individual liberties, if you look at the Bill of Rights, they say what the states can't do to you. They say what the federal government can't do to you. But as he put it, it doesn't say what the federal government or the state government must do on your behalf. He's absolutely right about that. Individual liberties in the Constitution are protections against government interference in certain parts of our lives. They protect private property, personal privacy in the home, freedoms of political and religious expression, etc. But they don't guarantee us affirmative rights to education, health care, or guaranteed income, and so forth. And, many people think, like Barack Obama felt, that we should have a constitution that does that. Former Justice of the Supreme Court Ruth Ginsburg talked a lot about that as well. Should we have a constitution that speaks more about affirmative rights rather than negative rights? Negative meaning freedom from government interference, not the right to expect government help. This is another interesting one, equal protection of the laws. Theoretically, we're all supposed to be treated equally by the laws and courts of our nation and states. I always find this amusing. I mean, you take the example of Donald Trump. I mean, if we take his case alone, his many criminal cases and civil cases, has he been treated the same as everybody else, as poor people who come before the courts? I don't see how you can make that argument. I think he has proved that he is above the law, and he's not alone. He's not the only person. A lot of rich people really have placed themselves above the law with their wealth and their lawyers and their ability to delay and obstruct the legal process using the tools of the legal process. It's not that this is not a crime or anything. It's just that they are able, if you have more and better and more expensive lawyers, they can drag things out to the point where you never face consequences. And many people have succeeded in doing that, not just Trump. But the principle is there. The principle is that we're not supposed to be treated differently based on our demographic characteristics, our race, our religion, our ethnicity, our national origin, our wealth, what groups we belong to, and so forth. That's what it's supposed to be. Is it? That's another question. And note that this does not include the idea that the government has to guarantee any kind of equality of outcomes. Often we speak of equality of opportunity in education, in the workplace, etc., in housing, but that doesn't mean that the government has to guarantee any equal outcome. And this is what Barack Obama and others would see as a shortcoming of the Constitution, but it is certainly one of the principles. And this raises another question. What can the government do to promote equality without infringing on the individual liberties, such as the individual right to property? Because sometimes the effort to produce more equality can run afoul of people's claims about their liberties. Now, just take a minute here on this whole question of, I mentioned this earlier about the elites and masses, and I just want to touch on this as a way of leading into the second video. The society, when I referred to it as a stratified society, this is what I'm talking about here. There were people at the top. They were more educated. They were wealthier, merchants, often in many of the northern cities, people who engaged in trade and shipped things across the ocean and among the different colonies. Plantation owners, who they sometimes usually called planters in those days, most of whom were slave owners who were in the South, lawyers, bankers, etc. Other people who had more wealth and power than others. And then there was another group they called, before the revolution, the royalists, pre-revolution. They were the ones who owed their jobs and their land to the King of England. And I say pre-revolution because once the revolution happened, they lost their property, they lost everything, and they fled the country, and most of them went to Canada. Some went back to England, but mostly just left the country and went to Canada. And they basically just lost everything. And then there was, if you go down the ladder, successful farmers, shopkeepers, independent artisans, the early sort of foundational middle class, mostly in the cities. And then you go down below that out to the rural areas, the so-called freeholders, people who engaged in fishing, people who cut down trees for a living, dock hands, etc. And then below that you'd find indentured servants and people who who lived on other people's land and had to work for them for periods of years. And below that, the enslaved population of the South who had absolutely no legal rights at all. So you can look at this and see this whole notion, this Walt Disney notion of a whole bunch of like one big happy family of Americans is really ahistorical. It is completely ahistorical. This was quite a stratified society that had social classes. Now the reason this is significant is because I won't go into a lot of detail about this, but understand how the revolution happened. The revolution and independence happened in part because the British government increased taxation on the rich. They started taxing commercial activity. There was a tremendous war, which the Americans referred to as the French and Indian War, but that's not what others call it. But the point is, it was a war that was fought in Canada, New England, and elsewhere, and it was a very expensive war for the British. They found themselves strapped for cash, and they imposed a whole lot of taxes on commercial transactions that really angered wealthy people and led to them feeling that they were the ones who were oppressed, that they were the ones who were being taxed without representation. That's where the taxation without representation slogan came from. It was rich people who felt they were being taxed. What ensued was tax protests and boycotts of British goods. The radicals got heavily involved in this, the people we call the radical Democrats. There was a Boston Tea Party dumping tea into Boston Harbor, etc., organized boycotts. And the British responded to a lot of this protest with repression. The radicals were essentially taking the part of the rich, but it was a convergence of interest because it's not that the radicals liked the rich, but they saw an opportunity here to get political reform, to get more democracy. But what happened was all the 13 colonies began to move not in the direction of political reform, because the British wouldn't reform anything, but in the direction of movement for independence, because they couldn't get any reform. So there was a whole series of events here, the Continental Congress, the battles of Lexington and Concord. I know you've heard this, but in essence, the Declaration of Independence came, 15 months after the shooting started. The country was governed during the war by the First and Second Continental Congresses, and in essence, what happened here was the elites got divided. During the war, the Continental Congress was controlled in large part by radicals, farming and urban artisan interests, and they controlled the money. The money was flowing from bondholders, who I'll talk about in a minute, to the Continental Army, but it was being restricted by the Continental Congress. Now, the military commanders in charge of the army who wanted that money were a bunch of upper-class merchants and planters with military training. And they were quite angry. I mean, Washington was furious with Congress for not releasing more money so that he could feed and clothe and get his men through the harsh winters and so forth. So the interesting thing was the rich were funding the revolution and they were commanding the army, but the Continental Congress controlled the flow of money because they controlled basically the bond holding. Now, bonds, governments issue bonds as a way of borrowing money. That's when we say bondholders, we're talking about people who lent money to the Continental Congress to fight the war. Now, you've probably read some of this business, but I just, briefly, there's a picture here showing you Washington's army, crossing the Delaware, etc. This was a time of great hardship and conflict, and I just think it's important to understand that it was a difficult war in which there was a lot of disagreement among the people who were running the government through the Continental Congress and the people who were running the army. You had rich people running the army and a bunch of, from their standpoint, state legislature radical types controlling the purse strings of the new government. Now, after the Revolution, the country was governed from 1781 through 1789 by the Articles of Confederation, a really failed document that in which state legislatures, 13 of them, were trying to make policy. And there was no real strong national legislature that could do much of anything. The national government was quite weak. The state legislatures were responsive to um, the less wealthy and less powerful aspects of society. And I'm not saying that's a bad thing. I don't think it's a bad thing. I'm just simply saying you had 13 separate governments trying to govern what was aspiring to be one country, and it really didn't work very well. You had 13 separate state polities, 13 separate economies, a weak national government, no direct taxation. Um, and the people who had lent money to the government were really worried because they felt they were never going to get their money. They thought it was very likely that they would never get paid back. But this government didn't even have a real taxing power. So these merchant and planter interests were out of power and felt threatened by state legislatures that they thought would be coming to take their property from them. They also wanted one big national market to trade in instead of 13 small ones. So you have all these problems with the Articles of So in summary, here's the problem. Under the Articles of Confederation, they had a weak national government that couldn't impose taxes directly, couldn't regulate commerce, no executive branch to implement the laws, no national court system, and no actual power over the states. So now the Constitution restored a lot of the power of the original colonial elites who had been put out of power. Basically, and when we go through the terms of it, the Constitution, you'll see what I mean. But they took away the state legislature's power to make economic warfare in each other. They protected the people who were owed money. They took away from the states the power to engage in foreign policy. They protected private property rights, said only Congress can regulate interstate commerce. There'd be one rule for interstate commerce, gave the national government direct power over the economy and foreign policy, gave it a taxing power, so that meant the merchants who lent money were going to get paid back. And basically, in essence, if the Constitution was ratified, which it was, the pre-revolutionary elites would be back in power. So there was a huge battle over ratification between the Federalists and the Anti-Federalists. The chief authors of the Federalist Papers who wanted to get it ratified were Madison, Hamilton, and Jay. They become the Federalist Party. Later on, of Washington, Adams, etc. The Anti-Federalists eventually become the Democratic Republican Party of Thomas Jefferson, and a long series of political battles ensue. In essence, the Constitutional Convention, was a meeting initially to replace the amend the Articles of Confederation that ends up replacing them. They were simply going to revise them, change them, amend them, but they threw them out and started over. And it leads us to this question of who the founders were. I'm going to conclude on this slide. These were people who had taken part in the Revolution, almost all of them. 29 were served literally in the army, most of them as officers. They were white male property owners, so they weren't very diverse in that sense. Nearly all of them had experience in politics, colonial state legislatures, the Continental Congress. More than half were lawyers, some were judges. The rest of them were mostly merchants, people involved in manufacturing, shipping, land speculators, bankers. 25 of them were slave owners, 15 of them were plantation owners, and most of them were major landowners and quite wealthy. George Washington was one of the wealthiest people in the country. So that's who they were. So we've talked about who they were, some of the political issues, and we've talked about the main ideas. And that's where we're really going to focus now, is on the terms and ideas of the Constitution and what they mean for us today. So I hope that's helpful to you.